Carrying on with letters patent and legislative authority, this is a little section from Crown Law written by Paul Lorden. And if you go to section 2.6.1, distribution of legislative authority, it says here, and we'll skip down a little bit, the provinces have jurisdiction over all lands, mines, minerals, and royalties belonging to them at the time of the Union, subject to any trusts existing in respect thereof. Letters patent issued prior to Confederation are considered trusts. So moving down now, the Municipal Act, Statutes Ontario 2001, general municipal powers. The powers of a municipality under this or any other act shall be interpreted broadly so as to confer broad authority on the municipality to enable the municipality to govern its affairs. And I'm going to say this now. How did my trees, given through letters patent through the imperial government of Great Britain, now become the affair of the municipality? So, as it considers appropriate and to enhance the municipality's ability to respond to municipal issues. I don't see how my trees would be a municipal issue unless they were falling over or affecting municipal land. We're going to go to a little bit of case law here, and Soccer versus Middlesex. The town of Middlesex, which is just outside of London, used letters patent in their defense. And what happened here was Mr. Soccer had a corner lot of 10 acres, and it was split into two parcels almost, 3 acres and 7 acres. And Mr. Soccer said, well, on one side is one parcel, then we have the province owns the water course, and then the rest of my property. So we have a natural severance. But the town of Middlesex disagreed, and so did the court. So what we get into, which I will call the Great Flip. Prior to Confederation, reservations were stated on the patent. Post-Confederation, reservations were all-inclusive unless they were the item was given in express words. So let's just read through paragraph 17. In my view, the legal effect of the Act, from a simple reading of its language, and the cases in that the absence of an express grant, the bed of the navigable water or stream, a patent from the province. Okay, this is post-Confederation when we have a patent from the province of land bordering on a navigable water or stream is deemed not to pass the bed of such body of water. See the case of Tadnat Club, as per Gale Justice. Such is not the case here. Here there is an express grant from the Crown, the land and waters laying thereon. In short, the Act does not apply. It matters not whether the waterway is navigable, since the fee, the right, is vested in the grantee. As stated by Mullock in Rice Lake case. In Rice Lake, what happened was a trapper had a provincial license to trap, and he entered it into the shallows on Rice Lake, which was patented in 1825, and he was trapping. And the owner of the island says, no, those are my animals, you can't. And he says, no, I'm trapping, I'm in navigable waters. Well, the court disagreed with that. The defendant in his evidence seemed to claim that the waters covering the portion of the plaintiff's company land were navigable, and that therefore he had the right from a boat to carry on trapping operations from there. Where naturally or by artificial means water covering the land of a private owner is navigable, a stranger, whether he has or has not the right of navigation in such water, is not entitled under the guise of using the water for navigation purposes to hunt, shoot, or fish within the precincts of such private property. Such is the right of the owner of the land. Again, in Tadnat Club, the court goes on to say, I am of the opinion, therefore, that after 1911, and what 1911 signifies is that that's when the Navigable Waters Act was brought into law by the province. If a person received a grant of land in Ontario beside or surrounding a body of navigable waters, he did not thereby receive ownership of the solemn, which the solemn is the soil beneath the water, unless the patent was so worded. And further, that by acquiring ownership of the solemn, he did not, as a result, become entitled to the exclusive right to fish unless such right was expressly given to him at the time or later. So this is a post-Confederation patent. Unless it states you own the water or unless it states you own the fish, you do not have the right to the water or the fish. It follows that had the grants of lands surrounding and under the waters had not been otherwise phrased, the plaintiff would not have gained title to the solemn and by statute would not have held exclusive fishing rights therein. However, because of the express grant of lands under Tadnak Bay and Tadnak Lake, and the fact that the plaintiff did receive a separate grant of the exclusive right to fish, it is now exactly in the same position as it would have been at common law, we're talking pre-Confederation, as the owner of the lands bordering upon a navigable inland waters, and that being so, it enjoys the exclusive right to fish those particular waters. If you get a moment, read Soccer and the two cases stated here. They're quite interesting. It gives you a concept between pre and post and how they flipped from being all-inclusive to being only expressed.